Following the Supreme Court judgment and a leaked memo from Federal Minister Festus Keyamo, debate over the Buni-led caretaker committee of the party and its future has been rife. And former Vice President Atiku Abubakar has been in Rivers State visiting Governor of Rivers, Nyesom Wike, and both are now joining forces. Hello, everyone, and welcome to Politics Today live on China's television. I'm Sean Kimbale in Lagos. Tonight, very interesting conversations that we have for you, but you need to stick with me because some of these conversations are mostly legal in nature. So I will discuss party issues and the state of the nation. So stay with me, everyone. Where do we begin from? Let's begin by telling you about the former Vice President Atiku Abubakar, who has expressed a hope that Nigerians are becoming more eager to see the People's Democratic Party, PDP, return to power in 2023 in order to solve the growing security and economic challenges facing the country. Atiku said that these at the River State Government House in Port Harcourt after a two-day private visit to Governor Nyesom Wike to, quote, reconcile with the governor on party affairs to ensure that the PDP is united and stable to win the 2023 elections. The former vice president described the current situation in the country, the security situation that is, as the worst in more than 70 years of his life. Well, before we go into other matters, let's get you to see some of your political roundup stories.
Justice Obiora Egwato of the Federal High Court in Abuja has ordered the Department of State Services to produce the 12 aids of Sunday Adeyemo, also known as Sunday Igboho. The judge issued the order following an appeal by the counsel to the DSS, Mr. Eduwawo, that the service be given another time to comply with the order. At the resumed hearing, counsel to the DSS told the court that they had no intention to keep the detained applicants indefinitely and they could not be produced in court due to the nature of their case. He asked that some of the names on the Federal High Court order were at variance with the list of those being detained and they had been taken away for verification of facts. Justice Egwato told the DSS that they should have produced the detainees in court as he had ordered before giving reasons why they shouldn't be granted bail.
Court has mandated the DSS to produce all the applicants on Monday. And so this is progress for us, and we are glad about it.
The Zamfara State Deputy Governor Mahdi Aliyu has raised alarm that despite the court order restraining the State House of Assembly for any impeachment move against him, members of the House went ahead to overreach the pending suit and disobey court order by scheduling sitting to proceed with impeachment proceedings. The Deputy Governor is raising the alarm on the heels of the State Assembly members who had given him 48 hours ultimatum last Tuesday to appear before them to answer some questions on alleged misconduct leveled against him. The Katsina State Governor Aminu Bello Masari has assured his determination to train new entrepreneurs across the state and enhance their operation to have more hands to work with. This is part of his plans towards his publicly announced retirement from politics and public office come 2023. A group of political parties in Lagos called the Coalition of Political Parties said they have scored the Lagos State Electoral Commission last year at 90% in the last Saturday local government elections, but frown at the turnout of voters seeking synergy between parties, electoral umpire, civil society agencies to sensitize people ahead of the 2023 elections to avert a reoccurrence of what happened last Saturday.
Don't leave these people, don't leave all these policies to people who don't have the love of Nigeria in heart. Come and put one of you out. Support him. He'll be there.
Ahead of the All Progressives Congress World Congress across the nation, a group in the Lagos APC known as Lagos for Lagos is raising issues on the conduct of the Saturday exercise. The group held a press conference in Lagos today.
Well, let's go into our conversation tonight. The first one that is, and is about the leadership crisis in the All Progressives Congress APC. Today, the National Secretary of the Caretaker and Extraordinary Convention Planning Committee of the APC, Senator James Akpandode, has said that the nationwide World Congress of the party will go on as scheduled to elect party executives. And the party says it will not go back on its plans. In a statement by the National Secretary of the party and a press conference held today, he says he is already inaugurated and delegated responsibilities to members and leaders of the party in conducting, supervising, monitoring the scheduled World Congress. Also, a lawyer of the party and a chieftain of the party spoke at a press conference to clarify the position of the law based on the Supreme Court judgment of yesterday. Take a listen.
I do appreciate the fact that intra-party crises and tendencies do exist in political parties. But people must be bold enough and be courageous enough to act within the ambit of the law. You don't attribute to a judgment what it does not contain. You cannot even read into an act what it does not contain. There's nowhere in the judgment of the majority where the efficacy of the office of our chairman, national chairman, was questioned. Nowhere. As a matter of fact, if anything, what happened was that the judgment of the tribunal that says that the holding of political office, party position, does not contravene section 183 of the constitution still stands. It should not be intimidated by anybody. Our party remain firm. The congress of the party will go on as scheduled on Saturday, inshallah. By the grace of God, everything that has been put in place will come to fruition. Everything that has been put in place by the party will come to fruition. Because you can imagine the kind of confusion that the country will have been thrown into if the judgment of yesterday had gone the other way.
So the judgment of yesterday, we spoke with the governor of Ondo State after that judgment, and it was victory for the governor of Ondo State, Rotimi Akeredolu, and the APC. But there is a larger implication of that judgment. That judgment was a technical one in nature. Don't forget that the premise in which Mr. Jagede and the PDP went to court was to say that the Bunil-led caretaker committee, who is not supposed to, according to them, they're debating and arguing that it's not supposed to be, had gone to INEC to submit the name of Mr. Akeredolu, and that, according to them, based on section 183, which I'm going to put to you so that we can have this conversation started, is that a governor cannot be in another paid job at the same time. So that is what section 183 of the Constitution says. It says, and I quote, "The governor shall not, during the period when he holds office, hold any other executive office or paid employment in any capacity whatsoever." That is the basis. But Senior Advocate of Nigeria and the Minister of State for Labor, Festus Keyamo, in a leaked memo, had given the party his opinion on the law and the implications, and was advising the party. Let me allow you to see in part what Mr. Festus Keyamo said. He said, and I quote, "The Supreme Court, therefore, any other person affected by the actions of the Buni-led committee will henceforth not fail to join him in any subsequent case in court. This includes any subsequent election matter in any part of this country and all the APC congresses that are about to hold. The Supreme Court has just weaponized all those that will be aggrieved by the APC congresses to proceed to court to challenge the competence of the Buni-led CECPC to organize the congresses and national convention. The judiciary will subsequently destroy the entire structure of the party from bottom to top. We are lucky the Supreme Court has just given us a great and useful hint to save our party just before the beginning of our congresses. We cannot gamble with this delicate issue. The time to act is now." And he gave options. And part of the options that he gave to the party is for not only that Governor Buni, but anyone holding any executive position in any government establishment as stipulated in Article 7 of the APC Constitution should urgently leave and the constitution of the caretaker committee of the APC. So tonight, I have two gentlemen that are going to be giving perspectives to these. I have Mr. Daniel Boala, a lawyer and a member of the Lincoln's Inn. He joins us from New York in the United States. And from our Abuja studio is a former member of the House of Reps, Honorable Bernard Miko. Thank you so much, gentlemen, for coming tonight. Let me begin with you, Mr. Boala. I've seen your write-up about the position of the senior advocate, Festus Keyamo. You think is wrong based on Section 183 of the Constitution?
Oh, thank you for having me, and good evening to your viewers. I find the opinion of Festus Keyamo, senior advocate of Nigeria, quite strange. First of all, because he was one of the individuals that helped in giving opinion that brought about the caretaker committee in the first place. And he held a very strong opinion that the caretaker committee is constituted by law in accordance with the law. Secondly, because he is not just a party stakeholder, he's a cabinet member. So there is a duty imposed on him to ensure that he comport himself with decorum and then address the matter in such a manner that it will not throw the party into political party insurrection. Now, the judgment of the court, since the delivery of the judgment, there was no problem. Everywhere was calm until his opinion was released. And then it sends the people into media frenzy. But even his opinion is faulted, both in fact and in law. Number one, the concluding part of what he said about the Supreme Court is completely wrong, with the greatest respect, because one, nowhere did the Supreme Court made a conclusive decision or verdict on the caretaker committee. And they are wise about that. In fact, what they said was that the justice of the case will not be served if they apply the interpretation of Section 183 without joining Mai Mala Buni. That is wisdom. Why? Because it is a principle of law that a judgment or a verdict is only a verdict on the merit where it is an evaluation by the argument, evaluation of the court based on the argument of both parties. So, and the court, the justices of the Supreme Court are no spirit to contemplate what Governor Mai Mala Buni will say, assuming he was joined as a party in the matter. That's number two. So that statement of the Supreme Court in passing has no correlationship with the executive functions of the caretaker committee. But let's take it even on the merit of the argument. If you look at Section 183 of the Constitution, it makes clear that a governor will not, while holding position in government, hold another executive position, paid or unpaid. I am not making the argument on the premise of the fact that he's a caretaker committee chairman and he's not paid. Because even if he's not paid, the word "or" there was held by the Supreme Court to mean it is in its disjunctive sense. So either you are paid or you are not paid. But the real question, really, is that if you look at Section 183 of the Constitution and juxtapose that with Article 17 and sub 4, because anytime a dispute arising from a political party comes to the court will never make a conclusion until in their decision they are able to evaluate the constitution of the party. So you cannot read Section 183 in isolation. You have to juxtapose that with Article 17 sub 4. And Article 17 sub 4 also made clear that you cannot hold executive position and another position concurrently. But the contemplation of both Section 183 and Article 17 sub 4 is based on Article 17 sub 1, which talks about tenured position. So the contemplation of the Constitution and the article is in reference to a position that is tenured by statute. Now, whether you're running for governorship, you run for 4 years, and then you give yourself again for another re-election for another 4 years without more. In a political party, you run for executive position is for 4 years, and then you throw yourself back again for another 4 years without more. In this case, the caretaker committee is not going to serve for 4 years. And so that position or that function is not tenured. It is a creation of the NEC acting under its capacity on behalf of the convention. They created the committee, and the committee are performing a specific task towards the convention. Therefore, they do not fall within the contemplation of 183 and 17 sub 4. it is not an executive position in the real sense of the word because it does not contemplate these sections that
So
I'm talking about.
let me quickly jump in before I bring Mr. Honorable Miko into the conversation. So if you look at the judgment of the Supreme Court, which might be cited in any case, because it's now going to join in the committee of our laws. Now, it's not like the justices, if the majority of the justices, the minority of the of the judgment yesterday indicates that Governor Malam Buni should not be the one submitting the name of the governor for the election, but the majority judgment does not look like it counters that. But the question was that Governor Buni was not joined in that suit because of the immunity that covers the governor. So it's not as if they disagree on Section 183, which binds on this matter, but because Governor Buni was not joined. So it was on a technical ground.
No, the position of the Supreme Court is that, first of all, they cannot make comment on the merit or demerit of the legality of Governor Buni until they are able to hear him. That is the principle of natural justice. So in other words, they are trying to say that if Governor Buni was joined, then we would have been able to properly evaluate the argument and arrive at a decision. But what I'm saying is that even if Governor Buni was joined, the Supreme Court will not have arrived at that conclusion that Governor Buni's functions are illegitimate. Why? Because I told you 183 and 17th of 4 all contemplate a tenured position. Governor Memala Buni is not occupying a tenured position by statutes. Now, the tenured position by statutes is the running of office for 4 years and renewable for another 4 years. So now, assuming NEC appointed this caretaker committee and give them a term that is 4 years or more, then they are acting contrary to the provisions of the Constitution and that of the party.
Let me bring in Honorable Miko. Honorable Miko, you have also, you sent out a position, you've written a position on this matter. Let me hear your view on, you seem to have sided with Festus Keyamo on this matter.
Yes, Shehu, let me thank you for having me. You know, this provision of Section 183 of the 1999 Constitution as amended is well known to stakeholders of the party, even before this time. But the apprehension was whether raising it was going to rock the boat until Supreme Court came out. And I commend Festus Keyamo of bringing this to the fore. Not only Festus, other senior lawyers have spoken in the same vein. Our prayer is that let our congresses not be dragged to an extent where we go back to the same Supreme Court that have raised this red flag before now. Reading articles of provisions of Article 17 of the party's constitution in conjunction with the 1999 constitution, I don't think is the right thing to do. You cannot bring party's constitution and read it alongside the constitution of the Federal Republic of Nigeria. We are worried in the party that if we allow it the way it is to grow, as it has happened in other states, that standing something on nothing will never stand. That is our fear. And the advisory given by Festus Keyamo, I am inclined to that advisory based on the fact that we stand good chances of winning the 2023 general election. I think the PDP, which is in opposition now, will not be happy that this fact was given out too early. They were waiting for the party to make these mistakes, then they drag us to court. But thank God that we are now aware that these are the dangers lying ahead. And we can avert it now by going back to drawing board and doing the recommendations that will avert this scenario.
Should there be any kind of worry? Because from the position of Mr. Bwala and what he has explained, it does look like it is a forced panic. It is, there was a panic that was not necessary because according to his position, is saying it's not valid. The panic is not valid, and the position of Mr. Keyamo is not valid in law. Should your party need to panic? But in any case, you ask yourself, the World Congress is already going on.
You see, the position of neither position of Keyamo nor position of Bola, can be held as the position of the Supreme Court. But what I'm saying, that it portends great danger if we can avert this kind of situation that is confronting us today. It has happened in Rivers State, where the entire political process was shut down. So if there is anything we can do now to avert this danger, I think it will be helpful to the party. As a political party, we want to win elections and be in government, not otherwise. And if we have been warned, we have been tipped off at this level, I think we can go back without beginning to speculate or contemplate what will happen at the Supreme Court. Nobody knows how it's going to go if we are dragged before the court again.
There are some suggestions that were made by Mr. Keyamo. How visible are these suggestions? Because the NEC, which is perhaps the second highest organ of the party after the National Convention, made this move, and they thought it wise, looked at the bodies of law, and they thought that it was necessary for an intermediary takeover of the party, for an extraordinary position to pilot the affairs of the party through the crisis. But the options that Mr. Keyamo has put forward, how feasible are these options?
Yes, you see, he has put up his own options as to the way forward. Other party stakeholders, they can meet and discuss the matter and say, look, we have had this situation before. In 1993, Chief Enos Shonokon, in the aftermath of the annulment of June 12th election, was appointed in an interim capacity as chairman of interim national government, to head the country while also holding position as an executive in the Royal Dutch Shell. And if you go back to that scenario, you begin to wonder, and that contravenes section 138 of the Nigerian Constitution. So if you go back to that, you begin to wonder, when the Constitution is explicitly clear about what should happen in the case of a governor and what should happen in the case of a president. So what we are saying with the party, we are the same party. We are not, nobody hates the interim caretaker committee that has been appointed. They've been doing a good job, and we commend them for the great job he has been doing. We are saying that let these issues be brought to the fore, and let nobody dismiss views of anybody as to how we can secure our victory in 2023.
All right, Mr. Buala, let me bring you back into the conversation. Let me allow you to respond to what Mr. Miko said. There are several options, or about two options, that Mr. Keyamo has put forward. Do you agree with some of the options? Do they look like the way to go for the party?
Well, first of all, some of the things he canvassed as options are not revelation. Already, the party is working towards a convention. Already, the party has earmarked dates for congresses. Already, the extraordinary caretaker committee is working towards perfecting the constitution of the party. In fact, had even introduced an idea of constitutional amendment that will better shape the party towards 2023. So there is no evidence to suggest that the functions and activities of the extraordinary committee has been contrary to the provisions of the constitution or to the interests of the party. Let me say for the opt-in time, the caretaker committee, let's say as in the case of the governor, he cannot, while he holds position as governor, go to the Congress and run for the position of the national chairman or any other positions of the party. That is the contemplation of law. He cannot run for a tenured statutory position. Then all other committee members. But the convention is the highest authority of the party. Now, if you look at Article 13, and the convention, the National Executive Committee, is the second highest decision-making body of the party. But our constitution says that the National Executive Committee can carry out the functions and duties of the convention in between conventions. In other words, NEC is an interim convention. Every functionality of NEC is consistent with the powers of convention. Now, acting under its power, they created this extraordinary caretaker committee to prepare for the convention. That is consistent and that is lawful. The caretaker committee are performing the duty as ascribed to it by the NEC flowing from the authority that they received from the convention. Now, I told you 183 and I told you 17th of 4, they all contemplate a statutory position that is tenured for 4 years. You cannot run, you can't be a governor and also run for a position. The national chairman, who is a sitting governor, is not running to become a national chairman in the forthcoming convention. He is not running to carry out any other positions in the executive position in the forthcoming Congress.
Mr. Boala,
he is acting.
Yeah. Sorry. Apologies to butt in on your line of thought. But Honorable Miko made some statements in relation to what the party has seen in the past years. In 2019, the experience in Rivers State, your party's name was not even on the ballot. In Zamfara, in Bayelsa, the party has been beaten like as if it had a scorpion stung it in that election. Has the party learned any lesson from all of these legal complications and these technical legal issues?
Cases are determined on their own merits, and cases have to be all false before you can rely on them. That is the principle of law. The case in Zamfara has no correlationship with the present case in question. In Zamfara's own, there were complications arising from primaries, and the court held that there was no valid primaries. Therefore, there was no participation of APC. It does not apply here. Here, MEM officers duly appointed by the NEC are performing the duties as required. Now, let me tell you the confusion. The confusion is that, just like you rightly said, they created a false alarm. What the Supreme Court did not say was what was reflected in the opinion of Festus Keyamo. Supreme Court can never reach a conclusive decision on a matter that they do not hear the parties. And in any case, they are talking about dissenting decision and majority decision. So it has not created any situation where Festus Keyamo and people who share his views are calling for the dissolution of the NEC members because of a conjured decision of court.
We are due to close this segment. Honorable Miko, let me get your final view. Yeah.
Sure.
Go ahead, please.
Sure. Okay. You know that the NEC of APC, acting on behalf of the National Convention, gave a tenure, an initial tenure of 6 months to the caretaker committee. That on its own is a tenure. And it was extended once, and also the second time, making it twice. So if anybody is insinuating that their administration or of the caretaker committee had no tenure, I think that is a mistake. For the fact that they didn't run for office for an established tenure envisaged by the Constitution, that does not mean that their administration is or was open-ended. It has a fixed tenure, even if it has been extended twice. So the administration had a tenure. What we are saying, Sheung, is that this is a red flag that has been raised. And look at the situation in Rivers, where I come from. The same thing happened, and it was shut down at the wee hour of the election, and nothing could be done. And today we have no single candidate or officer in any form of representation from Rivers State, either in the National Assembly or in the State Assembly, even local government. So we are pleading with the party that this is an opinion that could be looked at rigorously while we find ways of moving forward, because it would be too dangerous for the party, after winning the election in 2023, to now face this kind of
Honorable Miko, we need to go now.
Today.
Yeah. So, Mr. Boala, if you have 10 seconds, your final word, we need to go now.
Well, first of all, Festus Keyamo, if he has an opinion, he ought to have written a memo to the chairman or to the president or to the party that has a legal department. But the party has chosen, he has his own reasons for doing that. But whichever way you put it, it is flawed in law because it is not substantiated by the relevant provisions of the law that anytime we talk about tenure, it must be statutory, it must be tenure that is in status.
Mr. Daniel Boala, a lawyer, member of the Lincoln team. Thank you so much for your time. And Honorable Bernard Miko, a former member of the House of Representatives. It's a pleasure seeing both of you. Thank you so much, gentlemen. We'll take a break now, and our next conversation will be with Mr. Femi Falana, a senior advocate of Nigeria, and we're going to be getting his views on human rights in Nigeria and the citizens' rights. Stay with us, everyone. We'll be right back. Thank you so much, everyone, for staying with us right here on the program. Just before I bring in my next guest, whom I've introduced to you, Mr. Femi Falana, let's tell you what is happening or what happened today in Anambra State in the camp of the People's Democratic Party, PDP. One man that is optimistic about the situation despite all the odds is Valentine Ozigbo, who organized a town hall meeting today. At our town hall meeting was the former Governor Peter Obi, and the governorship aspirant, Valentine Ozigbo, is confident that he will emerge the party's candidate at the end of the day despite the court cases. He held a town hall meeting in Awka today where party leaders in the state, led by former Governor Peter Obi, were in attendance and they were strategizing ahead of the November 6th governorship election. Take a listen to him.
Whatever sacrifice I will make personal to make sure we go together, trust me, I'll play my own part. I want to be the consensus candidate of a greater majority.
Valentine Ozigbo there. So let's switch now and discuss some issues relating to legal matters and, of course, the rights of Nigerians. We've seen a lot of agitations in the land, from those who are agitating for Yoruba nation to those who are agitating in the southeast region of the country. But exactly how do we tame all of these agitation if we think that being together as a people is the right thing to do? The unity of this country, they always say, is not debatable. I have Mr. Femi Falana here, who is also the lawyer to Sheikh El-Zazaki, who in Kaduna State yesterday, the court discharged and acquitted himself and his wife. Mr. Femi Falana joins us from Ikeja, GRA Ikeja area of Lagos. Thank you so much, Senior Advocate Femi Falana, for joining us tonight. I mean, we followed the El-Zazaki case, but it has a larger implication under the law and, of course, in the case of civil unrest and human rights in Nigeria. Let me get your take on this, what has happened over the last few years on Sheikh El-Zazaki.
Well, yesterday, the Kaduna State High Court discharged and acquitted them on the basis of our no-case submission. Following the service of the warrant of release on the prison authorities, or the authorities of the Kaduna Correctional Center, they were released. I mean, both Sheikh Ibrahim Ezaki and his wife, Madam Zenat, were released, and they are currently enjoying their freedom. They have been released, contrary to expectations of many people, because many people have been calling me since yesterday, oh, are you sure they are going to be released? Would this government obey the order of the court? But I can say without any fear of contradiction that, you know, they have been released. The authorities of the Correctional Service of Nigeria complied very promptly with the court order. And so I think it's a good development, having regards to the fact that since December 14, 2015, the couple had been detained initially by the State Security Service, and we were in court. And on December 2nd, 2016, the Federal High Court ordered their release and awarded damages of about 50 million naira to both of them. The federal government treated the orders of the court with contempt, absolute contempt. Of course, the Shiites mounted pressure on the government by protesting on the streets of Abuja. In the process, many of them were killed. And at the end of the day, the government felt the protests were becoming a source of embarrassment. And that was why the Kaduna state government decided to charge the couple with some, an 8-count, took them to court on an 8-count charge. But as I'm saying, by yesterday, the court ruled that there was no basis for them to have been put on trial. Hence, the court upheld our no-case submission. So as I said, they have been freed.
So, I mean, it then brings me to a very critical matter. Human rights is very fundamental in our laws. And for our society to thrive also, people's voices need to be heard and their rights need to be protected. Well, how do we tame extremism? Perhaps, what is the place of the law? What does the law say about the extreme tendencies in people expressing their views or their rights?
Well, by virtue of the provisions of Chapter 4 of the 1999 Constitution and the African Charter on Human and People's Rights, Nigerians, and indeed all persons living in our country, are entitled to fundamental human rights. But we are in a very perilous time whereby we are being told by top government officials, particularly the Attorney General and Minister of Justice, Mr. Abubakar Malami, SAN, we are being told that human rights are not important and that national security take precedence over human rights and the rule of law. For me, with profound respect, human rights cannot give way to national security, because you must look at the totality of national security. That's not about the security of the people in power, it's about the security of the country. Hence, Section 14, subsection 2, subsection B of the Constitution provides that the security and welfare of the Nigerian people shall be the source of, the primary purpose of government. The Constitution does not say the security of the government, but the security of the Nigerian people. Of course, there are officials of the government, like the president and the governors, who are also part of the security of the nation. They represent, part of the security of the nation. Hence, any attempt to remove them from power or to attack any of them are either classified as treason or treasonable felony, because they also represent the state. And that also means that they must represent the interests of the entire people of the country and ensure, and they take oaths of office on their inauguration to respect the Constitution, to respect Chapter 4 of the Constitution and Chapter 2 of the Constitution in particular. And so, if they or any official of the government or any agency of the government violates the rights of Nigerians, you have to go to court. And once the court has given a judgment or given an order, no authority has the power in Nigeria to decide, oh, we are not going to obey this order because we consider in our own office that, this judgment of a court is not in consonant with what we feel, what we think is national security. And if you maintain that position, you are violating section 287 of the Constitution, which provides that the judgments of our court, the decisions of properly constituted court, shall be binding on all authorities and persons in Nigeria. In the case of the Ezekizakis, between December 2016 and May 2018, when they were now arraigned before a high court in Kaduna State, the government could not defend the reckless infringement of their rights to liberty. And for me, this is a warning to all of us that we need to respect the rights of people, because sometimes you may also be the victim. You may be a victim of human rights violation. It has happened to people in power who were detaining people, frivolously. I was detained in 1985. But by the time President or General Muhammadu Buhari, as he then was arrested and detained for 3 years, his deputy, the late General Tunde Ide Agbon, detained for 3 years by the Ibrahim Babangida junta. We had to rally around ourselves, those of us in the human rights community, notwithstanding that we have been brutalized under that regime, to insist that we have to demand for the release of these two gentlemen. And our position then was that if we allow the Babangida junta to detain a former head of state and his deputy, and we simply keep silent, what will happen to the rest of us? And so we demanded for their release, and they were so released. So each of us will need human rights. We need to approach the court to protect our human rights.
That perhaps also, because what happened on the sideline of the Global Education Summit that President Buhari is attending in the UK brings me to the issue of extremism that I was asking earlier. At that meeting, there were conversations between President Muhammadu Buhari and the Prime Minister of the United Kingdom, Boris Johnson, and both leaders agreed that judicial process should run its course. And it was part of the review and the process and the conversation that they had that the war against different forms of terrorism in Nigeria should pass judicial process and be allowed to run its course. And President Buhari also asked Prime Minister Boris Johnson that they need help of Britain in fighting terrorism and also in achieving food security in Nigeria. And simply, the Prime Minister told President Buhari that, quote, "We are available to help." So I'd like to ask Mr. Falana, we've seen different kinds of agitations in the country, from the Sunday Igboho to Nnamdi Kanu to how do we tame these agitations?
Again, the question of human rights is involved here. Personally, I am strenuously opposed to the campaign for the balkanization of Nigeria along ethnic lines, because I believe that the masses of our people are oppressed by the ruling class and imperialism. And to that extent, I have a fundamental disagreement, a fundamental ideological disagreement with those who are calling for a breakup of the country along ethnic lines. But the law has imposed a duty on the government and the rest of us to respect the rights of such people. In fact, Article 20 of the African Charter on Human and People's Rights Act provides, guarantees the right to self-determination. So if a group of people decides to fight for a breakup of the country, the duty of the government is to try as much as possible to convince them to repose confidence in the corporate existence of Nigeria. But you cannot criminalize their demand, because it is not a criminal offense in Nigeria to demand, to make separatist demand. Government officials at the level of the presidency and the level of the governors are making separatist demands. When recently President Muhammadu Buhari ordered the Attorney General to go around looking for grazing routes, and the entire country never had grazing routes. But that, as far as the law is concerned, as far as I'm concerned, was a separatist demand.
Just a moment. Just 1 minute, Mr. Falana. I like us to fix some of the technical issues that we are having. We'll take a break, and when we come back, I'll allow you to continue on that thought. Stay with us, everyone. We'll be right back. Thank you so much, everyone, for staying with us. Mr. Femi Falana is still with us, Senior Advocate of Nigeria. Apologies, Mr. Falana, for breaking into that your thought. I just wanted us to be able to see you so that we can be able to connect to what you're saying. And thank goodness still we have been able to fix that issue. So please continue on that line of thought.
Yeah, I'm saying that when governors and other political leaders demand that the presidency of the country be rotated along regional lines, whether the presidency should go to the north or the south, that is a separatist demand. And so when young people are also influenced by the ideas of the ruling class to make separatist demand, we just have no business criminalizing their action. But be that as it may, with respect to Mr. Nnamdi Kanu, I did say to the government, if you want to bring him back to the country, please file a request and ask the British government to file extradition proceedings to bring him back. At the time he was found in Kenya, one would have expected our government to request the Kenyan government to initiate extradition proceedings, because among the Commonwealth member states, there is a treaty between Nigeria and Kenya. We have a treaty. And so, in the case of, but what we were told was that he was abducted and brought to Nigeria, contrary to international law, and contrary to the domestic law of Kenya. In the case of Sunday Igboho, again, despite my disagreement with him, I came out to say, you cannot just throw him into a waiting plane, as we were told was attempted. You have to go to court. You have to make a request under international law, under the ECOWAS Convention on Extradition. The government of Nigeria is requested to submit an extradition request to the government of Benin Republic. And so when our plenipotentiary, General Yusuf Buratai, retired, who at that time had not even submitted his letters of credence, asked for that Igboho be handed over to him. He was told, sorry, we operate the rule of law here. And that is why that matter is still in court. Now, the point I was making, and I've made the point today, with respect to the request of the American court, an American court, for the arrest of Commissioner of Police, Mr. Abakiari. I have expressed the view this afternoon that if he does not surrender himself, since he claims that he's innocent of the allegations, the United States government will have to submit a request to the government of Nigeria to extradite him to the United States, because there is a treaty between Nigeria and the United States which covers the offenses alleged. And once that request is received, the Attorney General will have to file extradition proceedings in the Federal High Court. So we have to show, we have to demonstrate that we are part of the civilized community, committee of states. And that is the only way we can be respected.
All right.
And unless we respect the rights of our people and the human rights of people in our country, we are going to be embarrassed continuously. And that is what has just happened in the United States, where a senator has moved a motion that certain weapons, aircraft should not be sold to Nigeria because of gross human rights violations.
So, Mr. Falana, we're due to close now. In the next 20 seconds, we are totally out of time. But I wanted to just point out that the federal government has not come out to say how they brought Nnamdi Kanu into the country. And the government of Kenya has come out to say, no, the case is not exactly the way it's been reported about how it was taken from Kenya. But just in 15 seconds, where do we go from here? How do we resolve this matter? A political conversation? Just 15 seconds.
No. What were told by the government was that there was an international collaboration among security agencies. And as far as the law is concerned, because Interpol was mentioned, the power of Interpol does not go beyond issuing a red notice and asking security agencies in any country to arrest a person wanted by another country or in his own country. And once that is done, Interpol does not get involved in the repatriation because the arrest is pending extradition, pending legal surrender. It's very embarrassing for Kenya, and that is why Kenya cannot say, oh, this gentleman was arrested in our country. But the British Guardian newspaper had already traced Nnamdi Kanu's passport, British passport, to the territory of Kenya, and that has not been denied. And that goes a long way to confirm that he was actually abducted in Kenya. The government of Nigeria cannot admit that we abducted him. Hence, they say he was intercepted. The government of Kenya cannot admit that he was abducted in their territory.
All right.
Because the human rights community in that country will take it up with the government. Nobody is saying that a criminal suspect should not be brought back to the country. More so, somebody who has done bail. But he has to be brought to the country, back to the country, under the rule of law.
Mr. Femi Falana, Senior Advocate of Nigeria, it's a pleasure having you speak on these national issues. Thank you indeed for your time. Appreciate it. Well, that's our show for today, everyone. Many thanks for watching. I'm Sean Kimbale. Bye-bye.